Greetings class, I'm your fellow student Kalia Carter, PAD 750 with Professor Adam Watt, and this is my podcast on the people versus Victor Garcia and his co-defendants Rafael Morel and Kennedy Tabares. What I'm going to do today is read you an excerpt of the trial transcript so that you can gain a better understanding of the facts and circumstances surrounding these indictments. On or about April 26, 1995, these defendants were observed by a police officer on patrol as they sat in an automobile in the parking lot of the Larchmont train station. This officer saw them move from one parking space to another where they would sit for a period of time and then move on to another parking space. When the three eventually left the car, the officer approached and asked what they were doing. Upon receiving conflicting responses, the officer sought and obtained from defendant Garcia consent to search his vehicle. Upon searching the vehicle, the officer found hidden under a floor mat beneath the car's dashboard a radio scanner and a digital audio tape recorder. When he asked the defendants the purpose of this equipment, he was told that they thought it was fun to listen to police radio communications and that they had been taping the conversations. The officer ultimately took the defendants into custody and impounded the vehicle. A subsequent search of the car revealed a cellular telephone on the rear passenger seat. Later investigation proved that the scanner found in the car had been programmed to receive coded information transmitted on cellular telephone frequencies. The digital audio tape equipment was found to have been connected to the scanner and contained a tape recording of encoded information transmitted on various channels dedicated to cellular communications. Among the recorded information were the serial numbers and code numbers of cellular mobile telephones. As to the cellular mobile telephone found in the defendant's car, an electronics expert for 9X determined that its serial number had been electronically altered and the telephone had been programmed to transmit an unauthorized access code number. The grand jury heard expert testimony regarding the so-called cloning of cellular telephones, that cellular mobile telephones are designed to transmit periodically on specific frequency, coded information containing the serial number of the equipment as well as the telephone number assigned to it, and that with the aid of a scanner and audio tape recording equipment similar to that found in the defendant Garcia's car, this information could be intercepted and recorded, and that through the use of additional equipment, the computer chips of cellular telephones could be reprogrammed to emulate electronically the telephones whose transmissions have been intercepted. What this means is an individual could make cellular telephone calls that will be billed to accounts of those whose electronic codes have been previously intercepted. Due to the inevitable delay between the placement of these calls and the billing for these calls, a cellular telephone that had been cloned could be used to make calls for a period of about 1 month before a telephone company could change the access code information to prevent further unauthorized calls. Evidence was also presented to the grand jury that the cellular phone found in the rear of Garcia's vehicle had been cloned in the manner just described. Based upon this evidence, the grand jury returned an indictment charging the defendants with the criminal possession of a forward instrument in the second degree, eavesdropping, unlawful duplication of computer-related material, criminal possession of computer-related material, possession of a police radio frequency scanner as a violation of Vehicle and Traffic Law 397, and possession of burglar's tools. Defendant Garcia was also solely charged with the violation of Vehicle and Traffic Law 402 Subdivision 1 for having his rear license plate insecurely fastened. The defendant now moves to dismiss the indictment for legal insufficiency. With respect to all but count 5, the application is denied. The evidence before the grand jury was sufficient to support the charge of criminal possession of a forged instrument in the second degree. The cloned computer chip and the cellular phone found in the rear of the vehicle contain encoded computer data. Computer data is specifically enumerated in the definition of written instrument contained in Penal Law 170.00 Subdivision 1. This instrument does or may evidence, create, transfer, terminate, or otherwise affect a legal right, interest, obligation, or status as defined in Penal Law 170.10 Subdivision 1, and the cloned chip was falsely made, as that term is defined in Penal Law 170.00 Subdivision 4, insofar as the evidence before the grand jury indicated that it had been encoded without the authorization of the rightful owner of the telephone number programmed into it. Therefore, the knowing possession of a cloned cellular telephone chip with the intent to defraud, deceive, or injure another constitutes the crime of criminal possession of a forged instrument in the second degree. Under the facts of this case, guilty knowledge can readily be inferred from the defendant's possession and use of equipment used in the process of cellular phone cloning. Thus, the evidence presented was sufficient to support this count of the indictment. Similarly, the actions of the defendants in accessing the electronic communications of the cellular telephone frequency without authorization constitutes the offense of eavesdropping under Penal Law 250.05. The taping of the cellular computer data, done as the evidence before the grand jury suggests, with the intention of furthering the cloning of cellular telephones, constitutes the offense of unlawful duplication of computer-related material under Penal Law 156.30, Subdivision 2. This also constitutes the inclusionary count of criminal possession of computer-related material under Penal Law 156.35. The possession of the scanner programmed to intercept cellular telephone information and the possession of the digital audio tape recorder adapted to record these data fit the statutory definition of possession of burglar's tools under Penal Law 140.35. While the legislature may have envisioned such relatively primitive implements such as crowbars and lockpicks when they enacted the statute, the definition given to burglar's tools encompasses the sophisticated equipment at issue in this case. These items were adapted for use in furthering theft of telephone services and the circumstances surrounding their use, including the simultaneous possession of a cellular telephone that had been cloned, but the use of the same type of equipment as that found in the defendant's car, evince an intent on the part of the defendants to use these devices in the commission of thefts of telephone service. Therefore, count 6 of the indictment is also supported by sufficient evidence. The evidence before the grand jury was not sufficient to support the 5th count of the indictment, charging the Vehicle and Traffic Law 397 violation, possession of a motor vehicle of a radio capable of intercepting police communication frequencies. The testimony of the electronics expert in the grand jury showed that the scanner used by the defendants was programmed to intercept only cellular telephone data frequencies. While the witness did testify that the scanner could be reprogrammed to receive police communication frequencies, the possession of a radio receiver that could be modified to intercept unauthorized communication does not rise to the level of crime prescribed in the Vehicle and Traffic Law. And the 6th count of the indictment against Mr. Garcia, charging him in violation of 402 of the Vehicle and Traffic Law, Subdivision 1, was also ultimately dismissed. The only evidence adduced in support of this charge was the testimony of the arresting officer that the license plate on the rear of the vehicle was only held on by a twist tie and is usually put on by screws. That is a violation of New York State Vehicle and Traffic Law. Aside from the assertion of the grand jury's function evidence in the latter sentence, as well as the incorrect statement of the law, count 6 must be dismissed for legal insufficiency. Section 402 of the Vehicle and Traffic Law merely requires license plates to be securely fastened so as to prevent them from swinging, and does not mandate the use of screws, bolts, or any particular fastener. Since nothing in the officer's testimony suggests that the license plate was insecurely fastened or free of swing, this count must be dismissed. In sum, the defendant's motion to inspect and dismiss or reduce counts of indictment is denied as to all counts save for counts 5 and 6. These counts are dismissed with the people to represent to another grand jury should they choose so. And there you have it, folks. Those are basically the facts surrounding the circumstances of the indictments held down at the hands of the court against Mr. Garcia. And as you can see, all but 2 counts held up. The vehicle and traffic violation for improperly fastened license plate did not hold up, nor did the operation of a motor vehicle equipped with a police scanner. That also did not hold up, basically just because they couldn't be proven that that scanner could be changed to a police channel to intercept police communications.